Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall.
Welcome back to another episode of Trust Me, It's Complicated with your host, me, John Marshall. I am the owner and operator here at Marshall Law. And at Marshall Law, we specialize in estate planning, probate, and guardianship cases. Today, I'm going to talk about guardianships. What are they? When are they used? And why is it that we try to avoid these? That's a question that we get a lot. So hopefully after this podcast today, you'll have a better understanding of what a guardianship is and why you and your family will want to avoid it, and then what we can do to avoid that. So what is a guardianship? Well, plainly, a guardianship is the appointment of a person to act on behalf of another person legally. So imagine I have a bank account in my name, I have dementia, I cannot handle my finances, and I don't have any documents appointing someone to act on my behalf. Now I need the court to appoint someone for me. That is a guardianship. And it's amazing how many times these become necessary simply because people have not taken the time to talk to an attorney because they think estate plan is when I die. No, 50% of estate planning is when you die. 50% is what happens when I'm alive and issues come up. And those issues can be temporary, they can be permanent. And oftentimes when we have an issue of dementia, that is a permanent capacity issue that must be addressed by the court if you have not executed proper documents beforehand. Now, when we open a guardianship, we have to open the case with two separate cases. One is a mental health case, two is the actual guardianship. So when we file the mental health case, what we are asking the court to do is appoint 3 examining committee members. These are mental health professionals, one of whom must be a physician, who are going to evaluate the person that has dementia and determine whether or not they have capacity or are incapacitated. And if they are incapacitated, how severely are they incapacitated? So when we go into the court and we ask to have a guardianship open, we file the mental health case, we ask the court to appoint 3 examining committee members. The court issues that order, and those examining committee members must examine physically and in person the person that is alleged to be incapacitated, and then within 15 days after that court order, submit a report, an evaluation to the court stating whether or not the person is incapacitated and in what areas they are incapacitated. Do they have capacity to manage their finances? Do they have capacity to drive, to vote, to marry? Think of it this way. What are our civil rights that we take for granted? And I say that because how many people vote in every election, not just a presidential election, and even in presidential elections, turnout is still pretty low. But yet that is a civil right. Well, imagine you are now incapacitated and there are certain rights that you have. To what extent is the court going to take away those rights? That is what the mental health case is all about. And the interesting thing is, I've had situations where people have gotten these reports back and the examining committee has said, hey, this person lacks capacity to do this, this, and this. And people will say, well, let's negotiate on what the court's going to find on that. There's no negotiation. If the examining committee, if 2 of the 3 examining committee members say the person lacks capacity, let's say, to marry, the court must enter an order saying they cannot marry. If 2 of the 3 say this person does not have capacity to determine their residence, the court must issue an order saying they do not have capacity to determine their own residence. So the mental health case is where we get the actual determination of capacity, and the court and the attorneys have no say. It's based upon what the examining committee comes back. Now, if there are questions about something stated in the report, maybe the examining committee members weren't as expressly clear as maybe we need them to be, we can take testimony and we can ask them to provide further evidence to substantiate what's in the report. But at the same time, the law recognizes that as attorneys and judges, we do not have the training to determine capacity. That's why we must rely on court-appointed examining committee members. And these are members that come off of a list that's put together by the Judicial Circuit Court. And the reason for that is We can't just go doctor shopping. Okay. Can't find a doctor that we know is going to say so and so is incapacitated, just like that person can't say, well, I'm going to go to this doctor because they'll say I'm not incapacitated. The examining committee members go through specialized training, screening, and they are picked by the state to serve on this examining committee. So we have a list of doctors and mental health professionals that we draw from, and those are the people who are only allowed to make that determination. Quite frankly, it's a good system. It's better than doctor shopping. And it does, I think, work pretty well in protecting the rights of the people that we're trying to have declared incapacitated. Now, that's the mental health case. On the flip side, we have the actual guardianship case. And in that one, the petitioner, you could be one person, could be multiple people, are also an applicant, submits an application saying, I want to be appointed as guardian if this other person has been found to have incapacity. We call that person the ward. So or the alleged incapacitated person. So let's say the examining committee comes back, says the alleged incapacitated person has no ability to manage their finances, determine their residency, and they lack capacity in all areas. We call that plenary. At that point in time, the court will determine whether or not the applicant is best suited to serve as the guardian. Now, when they're looking at that application, they're looking at what is your education level? What do you do for a living? What is your job history? What's your relation to the incapacitated person? And it's because what we are trying to do is make sure that if someone is appointed to act on behalf of the ward or the alleged incapacitated person, that person, the appointed guardian, has the training, the knowledge, the skill set to perform their duties in accordance with the law. What we're trying to do is protect the ward, and I'm going to use the term ward. When we have a person declared incapacitated, they go from an alleged incapacitated person to becoming a ward. So the applicant who's seeking to be the guardian over the ward, they submit that application, the court will evaluate them and, again, make a decision as to whether or not that person is best suited. Now, I've seen situations where applicants have been denied because maybe they have a felony conviction. Maybe they have multiple bankruptcies. There are different factors that may come into that. If somebody has multiple bankruptcies, does that make them a bad person? No, it doesn't. But are they best suited to handle the ward's finances? Maybe they're not the best suited to handle their finances. Okay. So again, it's a matter of the court trying to protect the ward. And in that circumstance, that's why the evaluation is done. Now, the problem is sometimes the court can't weed out the bad actors. And there is a family member that maybe is trying to get, control over the ward because they want to control their assets or they want to control other aspects of their life. Okay, that does happen. Or maybe the applicant is a very good person and best suited, but now comes another family member or a series of family members into the mix who are making allegations and doing all this stuff. And now the court is in a position where they got to try to decide who amongst all these people is best suited, or do they go with a third party called a professional guardian to fill that role? Now, that again kind of gets down into the weeds, and we really don't have enough time to get into all that. But it does make for some very, very interesting cases. We look at a lot of these court cases on television, and I've talked about previously how, it's great for drama. That's not really how things work in the legal world. But quite frankly, guardianships could actually make for some very good entertaining television if it wasn't for the fact that there is a mentally incapacitated person involved. And in that particular circumstance, that is the really tragic part, that somebody has lost the capacity to manage various aspects of their life. So there's a negative and sad element to this that, quite frankly, we tend to overlook from a procedural standpoint, but we can't lose sight of that. Now, when the court does appoint a guardian, at that point in time, it's not like that person just takes over and says, okay, now I'm in charge of everything and I'm going to just call the shots. No. Now we have to, as the guardian, go in, file an initial accounting of all the assets, file an initial plan saying, here's what we're going to do to take care of the ward's physical condition, mental health condition, health, and so forth. We file that, and then every year thereafter, until the ward dies, we have to file those reports. And this goes on year after year after year. And if there are negative, influences occurring in the family, there's a lot of fighting and other stuff like that, we may find ourselves back in court again and again and again. When people ask me, are there ever winners and losers in guardianships? I say, yes, there's losers. Everyone involved in the guardianship other than one winner. And that one winner is the attorney. And that's because attorney fees on this are pretty steep. And it's not because attorneys are trying to rack it up, but when the attorney who's handling the guardianship gets involved, they've got to file two cases. So the people paying that attorney are now paying for two different cases. And one thing that I didn't mention already is the fact that the court will appoint an attorney to represent the ward. And that attorney's job is to make sure that the ward's civil rights aren't being violated. Sometimes I would say actually most of the times they do a very good job of that. And on a few circumstances I found they haven't done a good job of that. But again, that attorney has to be paid. The examining committee has to be paid. The attorney that's performing the guardianship has to be paid. So at the end of the day, when someone comes to me and says, hey, I don't want all this. Maybe I don't want my family fighting over who's going to be in charge of me or my finances if I become incapacitated. What can I do? Well, as an attorney, that's where I'm going to look at them and say, we do not want guardianship. What we want to do is we want to do an estate plan that includes a power of attorney. And we're going to talk more in the next podcast about what a power of attorney is and why it's important. But simply this, a power of attorney allows you to decide who is going to manage my finances for me. And the court, even if a guardianship is filed, must give preference. Doesn't mean they can't overrule the power of attorney, but they will give preference to the person that you have chosen and named in your power of attorney. Now, oftentimes, why would a court remove an agent under a power of attorney? Well, maybe if the allegations that the person is abusing their power, using the ward's assets for their own benefit, things like that, are proven true. But even in that circumstance, in my powers of attorney, we have a backup named. And then we have another backup named. So even if one is removed, we still have two backups, which means the court may say, hey, you can't be agent under the power of attorney, but you two can. We still don't need a guardianship, meaning that we do not have the annual reports and the ongoing issues with the family on that front. Now, the other document that we should always have is a designation of healthcare surrogate. And what that document says is, if I can't make my own healthcare decisions, here are the people in successive order who can make them for me. Now, a lot of people assume, well, who do you name as your agent? Do you just name your spouse? Do you name your kid? Well, you know what? You've got to actually ask yourself, who is best suited to handle my finances? Yes, you may be married. I have a situation now where the husband executed power of attorney and he said, I do not want my wife being my agent. I love her. I'm leaving her everything in my estate, but I do not want her being my agent. And why? No, she's not good with money. She's not good at handling some of the different aspects of their regular life, and it's because he always handled it. She's not equipped to handle it. And he said, I want my son to handle it. And in that circumstance, why? Well, son's in finance, daughter's in finance. They are actually better suited to handle the day-to-day issues involving that gentleman's estate than his wife is. Okay. Now, it also could be, hey, maybe, again, I have a child who has a bankruptcy, or I have a child who's, got a drug history. Even if they're out of rehab, that's now you're handing them your money and you're saying, I hope you don't have a relapse or something like that. So oftentimes I ask people, you have to say to yourself, even though I may love these people, even though I may be related to them, even though maybe I trust them with some of the aspects of, issues in my life, do I want to put everything in their hands? And that's a personal question. And that's one that only you can answer. But it should be one that you seriously approach and consider in light of all of the issues that may be affecting you at a moment that you have lost capacity. But the nice thing is, if you decide, odds are those are the people that are going to control. We don't have the court case. We don't have a judge that you don't know, that you likely didn't vote for, deciding for you who's best to control your life. So again, this is why you need to talk to an estate planning attorney. My name is John Marshall. I would welcome the opportunity to speak with you about your estate, in particular about how a power of attorney or a healthcare surrogate can be an important part of your estate plan. So give us a call at Marshall Law. Our number is 352-432-8859. You can find us online at marshallawpa.com. In the meantime, have a great day. Thank you for joining me on Trust Me, It's Complicated. I look forward to seeing you in our next podcast.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.